Canadian colleagues. I am a co-chair of the IP Practice in Japan Committee of AIPLA. My esteemed colleague, Jason Murata, is the co-chair. We would like to welcome each of the JPAA attendees and AIPLA members to today's virtual meeting. We would, of course, prefer to be meeting with each of you in person. However, we look forward to this virtual opportunity to continue the long-standing relationships between AIPLA and JPAA. Before receiving opening remarks from AIPLA's President, Barbara Fiacco, I would like to remind everyone that today's meeting, except for the networking time after the closing remarks, will be recorded. Barbara, the virtual floor is yours.
Thank you very much, Todd. Good morning, President Shimizu-san, JPAA leadership, and all attendees. On behalf of AIPLA, thank you very much for meeting with us. I wish we could be together in person in Japan. I know that the delegation trip to Japan is a wonderful tradition that AIPLA enjoys and one that everyone at AIPLA greatly values. The collaboration with JPAA is really one of the highlights of AIPLA's international work. And I am very disappointed that I couldn't be part of the trip this year. I was even working on my karaoke song, but we'll have to save that for another day, and perhaps it's better that way. But I do look forward to this meeting and to meeting you all in person sometime soon. Thank you.
Thank you, Barbara. Next, we will receive opening remarks from JPAA President Yoshihiro Shimizu.
Thank you. Good evening, everyone in America. Oh, hold on. Okay. Okay. 入ってます。入ってます。入ってます。入ってる？大丈夫。大丈夫ですね。Good evening, everyone in America, and good morning, everyone in Japan. Thank you for allowing me an opportunity to make a welcome address for the AIPLA delegation on behalf of JPAA. I am Yoshihiro Shimizu, the president of JPAA. Currently serving my second year of 2-year JPAA presidential term. I'd like to extend a special thanks to AIPLA President Ms. Barbara Fiacco, the Board of Directors, and all AIPLA delegation for coming all the way to Japan virtually. You may recall my face because last year in April, we had a full day meeting as always, which includes the closed meeting in the morning, the open seminar in the afternoon, followed by the reception at the authentic Japanese restaurant, Kitaoji Akasaka ended up with a karaoke party where I sang together with past AIPLA President Sheldon Prime. That was my sweet memory. I'd like to note a long-term bilateral relationship between AIPLA and JPAA over the past quarter century. Especially, I'd like to appreciate the AIPLA's continuous contribution and dedication to all of our JPAA members over decades through more yearly meetings. This year, we will have a virtual meeting, which is unusual and a first experience due to COVID-19. I believe, however, this is a good challenge for us, allowing more flexibility for a long-term relationship, because it is borderless, free from cost for the trip and accommodation. Just a bit concern is the time difference between us. I'd like to conclude my welcome address with wishing health and safety for your families, colleagues, and yourselves. And also hoping a virtual meeting today to be fruitful. Thank you.
Mr. Shimizu, thank you for your very kind remarks. We too hope that your families are safe during these times. So today we will have 4 presentations. Each presentation is scheduled to last for 20 minutes. We will try to reserve 5 minutes for questions and answers. If any of our attendees have questions, please use the chat room functionality provided by Zoom. Our first presenter today will be Ms. Sharon Israel, and she will be discussing, I should say, providing an update on trial proceedings before the USPTO's PTAB. Sharon?
Thank you, Todd. Let's see. Just ask, can you see my screen?
Yes, we can see it.
Okay, I am going to be providing a brief update on trial proceedings before the PTAB. I have more material included in my slides than I'm going to be able to cover, but hopefully you'll find the materials useful, and I'll be happy to answer any questions about them later. So there's been a lot of activity at the PTAB over the past year and in this past fiscal year. And the topics that I will briefly address will be some statistics of what's been of trial proceedings before the PTAB. I will talk a little bit about precedential decisions at the PTAB and give a brief update on motions to amend. I have some additional materials. I don't think I'm going to have time to get to those in the limited time that I have, but I'll be happy again to answer any questions about any questions you may have. So these are some statistics that are taken from the USPTO's trial statistics that were updated at the end of last month. And what you see on this slide shows the petitions that were filed by technology in the past fiscal year, which started on October 1st of 2019. And this includes numbers of cases that were filed through the end of last month. This is a breakdown by technology and of trial filings. And you'll see that the vast majority of filings are in the electrical and computer arts, with about 63% or 765 cases that were filed since last October. The second largest technology area is business and mechanical and business method patents, followed by chemical and biopharma, with a small number of design patents as well. This next slide, also from the USPTO's trial statistics, shows the petitions that have been filed by month over the past 12 months. And what you can see from this is that there's been the number of IPR petitions has gone up in the last couple of months, although over the last 12 months, the average number of IPR petitions filed is about 115 per month. The lower graphs show the minimal number of CBM or covered business method patents that have petitions that have been filed, and PGRs, post-grant reviews, which are limited to post-AIA issued patents in their first 9 months after issuance. So while there are some PGRs that have been filed, the vast majority of the trial proceedings involve inter partes review, or IPRs. Now, the next slide shows institution rates since the trial proceedings began in October of 2012 to the present. And the institution rates have declined fairly significantly since the initial inception of the proceedings, where there was an institution rate of 87%, to what we're seeing this fiscal year of an institution rate of 56%. In my view, that is likely because of the board issuing a lot more discretionary denials of institution at the outset. However, what you'll see is once an IPR proceeding is instituted, the outcome of the proceedings is fairly successful for the petitioners have a high success rate. Once initiated, the petitioners have about in 80% of the cases, some or all of the claims in final written decisions were found to be unpatentable. So with that background, I'm going to next talk a little bit about precedential opinions. And there's been a lot of activity over the past year with respect to precedential opinions. There are two methods of which a decision can become precedential at the PTAB. One is through something that is called precedential opinion panel review, which is based on a standard operating procedure that the board started about just under 2 years ago. And the precedential opinion panel is comprised of the director of the USPTO, Director Iancu, the chief administrative patent judge, currently Scott Bolick, and the commissioner of patents. And those three make up the precedential opinion review panel. And they POP, as the POP, Precedential Opinion Panel Review is sometimes referred to, will address issues of exceptional importance concerning major policy or procedural issues and potentially resolve conflicts in board decisions. There were 3 POP decisions in the past year, and I will discuss those briefly. But first, I want to mention that there's another mechanism for designating decisions as precedential, or what's called informative, and I'll discuss that briefly as well. And that is by the director. The director can designate a decision as what's called precedential, meaning it's binding on the board, or informative, meaning it's not binding, but absent a reason not to follow it, the board will generally follow it. And the director can designate decisions as precedential or informative. The director does this with the recommendation of a screening committee. And the screening committee includes the executive judges of the board. So that would include the chief judge, the vice chief judge, the deputy, and they would make recommendations to the director for precedential decisions. Okay, first I'm going to next turn to the 3 precedential POP opinions that issued in the past year. So the first one is one that deals with something of a technical issue, and that was the GoPro versus 360 Heroes case. That dealt with an issue involving the time bar for filing an inter partes review petition. So one of the limitations in filing an inter-parties review petition is that you have 1 year from the time of service of a complaint in district court to file a petition. In the GoPro case, there had been a defect with respect to the complaint that was filed in district court. And initially, the board had instituted the IPR proceeding. The party petitioned to the POP panel. The POP panel re-reviewed the decision and came out the other way and said that the IPR proceeding was time barred. What they said was that service of a pleading asserting a claim that alleges infringement triggers the 1 year time bar for a petitioner to file a petition, an IPR petition, even where the serving party lacks standing to sue or where the pleading is otherwise deficient. So even though there was a defect in the district court proceeding, that service of that complaint was sufficient to trigger the 1 year time bar. In another precedential POP opinion, Hulu versus Soundview Innovations, here the board dealt with the issue of what evidence is needed, how much evidence is needed at the institution stage to show a reference as a printed publication. And this is in this instance, I will mention that AIPLA did submit an amicus brief to the POP panel in this case, and the board decision is fairly consistent with the AIPLA position in its brief. So the board said that at the institution stage, the petition has to identify with particularity evidence sufficient to establish a reasonable likelihood that the reference was publicly accessible before the critical date of the challenged patent, and therefore that there is a reasonable likelihood that it qualifies as a printed publication. But it did mention that there's limited opportunity. There are opportunities for the petitioner to present new evidence to deal with proving up the reference as a printed publication, and there's no presumption in favor of institution or in favor of finding a reference to be a printed publication, but the burden will always remain with the petitioner throughout the proceeding. Another case where the POP panel reviewed and issued a decision just last month was in Hunting Titan versus Dyna Energetics Europe. And in this case dealt with the issue of dealt with an issue of the burden on a motion to amend and whether the board could supply its own reason of unpatentability in denying a motion to amend where there was an amended claim that was presented by the patent owner. The POP panel said that the board may only, in certain rare circumstances, raise a ground of unpatentability that a petitioner did not advance or insufficiently developed against substitute claims proposed in a motion to amend. And they found that in this instance, those circumstances didn't exist and the board should not have raised its own ground of unpatentability. So here, they said the petitioner's grounds were insufficient and the motion to amend was granted. And AIPLA did submit an amicus brief in this case as well. So I mentioned precedential opinions, which are designated by that can be designated by the director at the recommendation of the executive review judges, executive review panel. And there were 6 decisions that were designated precedential in this fiscal year thus far. 3 of those decisions deal with discretionary denials at the institution stage. The board also, the director designated a number of decisions as informative. So informative means that the decision should be followed absent justification, but they're not binding legal authority. And decisions that aren't either precedential or informative are routine, meaning that they apply in that case, but they don't have application, or they aren't binding outside of that particular case. So you'll see I've got 2 slides showing decisions that have been designated informative, and they deal with issues including printed publication, institution and discretionary denials, motions to amend, in addition to some other decisions relating to obviousness. All right. And speaking of motions to amend, I'd like to just discuss some trends on motions to amend, and then I will briefly conclude. So what's shown here are the number of motions to amend that have been filed since inception. And what you'll see is that there are not very many. 80% of the trials were completed without a motion to amend. There were 504, 9% of the trials that were completed with pre-pilot with a motion to amend. We have a new pilot program on motions to amend. There are not yet any completed trials, so we don't have statistics to present there. Now, with motions to amend, the success rate has not been very high to date. There were only 27 where substitute claims were granted, and 19 or 6% where they were granted in part. Otherwise, 86% of motions to amend out of 335 filed in the pre-pilot program were denied. So last year, the PTAB began a pilot program where there's an opportunity for parties, for a patent owner, to present substitute claims, request preliminary guidance on those claims, and get a written non-binding decision from the board. And then they can have a second opportunity to submit a revised motion to amend with revised claims that would presumably address issues that might be raised by the preliminary guidance. So thus far, there have been 77 motions to amend under the pilot program. There were 67 requests for preliminary guidance. The board has issued 39 instances of preliminary guidance, and there have been 26 revised motions to amend. So it's still a little early to see how the pilot program will play out, but the bottom line is that the PTAB is trying to make motions to amend and taking some steps to make motions to amend more attractive, and we will have to see if practitioners and stakeholders agree that it is indeed a improved program that they'll make more use of. So with that, I think my time is up, so will go ahead and stop for now and take questions.
Hi, Sharon. This is Todd. I did type a question into the chat room. I was wondering, why do you think that there's been an increase in precedential opinions during the past year?
I would say that I think that Director Iancu is taking a concerted effort to try to make proceedings as fair and balanced as he can, and to make the there had been a fair amount of attack on the board with respect to how petitioner friendly the proceedings started out, as you saw with the 87% institution rate. And I think he's made a concerted effort to try to address more consistency among panels, to address issues in particular involving discretionary institution. We saw some trends in some of the precedential decisions. So we've seen ones in discretionary institution, we've seen ones in with printed publication, obviousness, and I think that's part of this, and motions to amend, and I think that's part of that effort.
Thank you.
I see a question from Konishi-san on motions to amend. Understanding the proposed rulemaking on burdens. Currently, does the patent owner bear the burden to show that the to be amended claims are patentable? No, in fact, the burden always is on the petitioner. While it may seem a little bit odd or a little counterintuitive, because the statute says that the petitioner always has the burden to show unpatentability, the burden on motions to amend, it still remains on the patent owner to show that the claims are unpatentable. Now, any amended claims do have to be directed to overcoming the grounds for unpatentability, and they can't be broadened, and they have to meet certain requirements. They have to be supported by the written description. So there is some logic in maintaining the burden of proof on the petitioner. Any other questions?
Sharon, yeah, I have one other question. Instead of filing a motion to amend, should parties consider filing an ex parte re-exam during the IPR?
So that's a good question. And about the same time that the pilot came out for the motion to amend pilot, the board also issued some guidance on use of re-examination and reissue in conjunction with AIA trial proceedings. And I do think that certainly remains an option. There are some benefits of the trial proceedings in that you know that you'll get a result in a certain time frame, and there may be some reasons, however, to go ahead and try to use ex parte re-examination instead, or if you have claims that are pending, to go ahead and just file continuation applications and see if you can get new claims allowed through examination.
Thank you very much. Any more questions for Sharon? All right, thank you very much, Sharon. Our next presenter will be Tamatsu Okato-san, and the topic will be the doctrine of equivalence in Japan.
Excuse me.
Yes.
It's Kenji Sugimura. I'd like to ask you one question.
Yes.
Sharon, thank you very much for your interesting, informative presentations. You referred about motions to amend.
Yes.
I'm now recording about 7-8 years when your newly revised AIA introduced. The newly AIA wanted to have expedite the proceedings in order to make a final decision within 1 year after filing the appeal. But this sort of MTA, and also I was referring your slide number 17, LEAP, which very seems user-friendly system, but it may jeopardize to achieve this one-year decision goal. It seems it may have a possibility to prolong the proceedings. What do you think about this? Could you elaborate some more about it? Do you see what I mean?
Was the question has to do with prolonging the proceedings based on the motion to amend pilot?
Yes. Yes, and also you haven't yet touched, but you included LEAP, the real experience and advancement program. These two are for very user-friendly device systems, but to me, it may have a possibility to make the proceedings prolonged.
So are you referring to the slides, the materials that I have that have the timelines?
Yes.
Yes. So
Such as slide 19 and 22.
so I think I can share.
I'm not actually criticizing your new systems, but what do you think about this?
Right. It
7 8 years ago, AIA was introduced, but one of the big purpose was that in order to expedite the proceedings. But if you introduce these new systems, it may have a possibility to prolong the proceedings. So that 1 year making decision from filing the appeal may not be realized.
So
I will elaborate a bit more about this.
I think that the procedure, especially if there is a revised motion to amend, it compresses the schedule and can make the proceedings more expensive, and also does make it more difficult to finish in that 12-month time frame. I know, one of the goals when the board came out with this pilot was to try to maintain that 1-year schedule, even though it is aggressive. So I am not aware at this point whether they have extended the time in the proceedings with motions to amend where there has been a revised motion to amend. I think they're still trying to stick to the time frame, but we'll have to see when we actually end up with some final written decisions, and if they are staying with the 1-year time frame, which is admittedly very aggressive.
Okay.
Okay.
Thank you.
Thank you again, Sharon, and thank you for the very thoughtful questions and answers. Our next speaker will be Okato-san, who will be discussing the doctrine of equivalence in Japan and its comparison with the DOE in the United States.
Sorry, I try to show them my slide, but I cannot share my slides.
I should be able to share them.
Share? Can you see my slides?
Yes.
No. Yes or not?
we see your home page, your desktop.
Just this.
Can you see mine?
Yes.
Okay.
Someone is, I cannot share. Someone is still using over there. That's it.
Oh, do you want to try again?
Oh, could you stop? Could you quit your
Yes.
presentation?
Yes.
これか。出ないね、これは。出てこないな。共有か。出てこないな。どうすんだ、これは。
岡戸先生、
はい。
スライドショーで、上のリボンのスライドショー。
スライドショーの、はい。
はい。
スライドショーがね、いや、もうスライドショーに入ってるんですよ。私の画面では。だけど、共有が出てこないんです。
今、今、岡戸先生、画面共有されているんですね、すでに。
そうですね。
はい。ただ、スライドショーになってないので、ちょっと、もし、難しいようでしたら、シャロンさんの方で、プレゼン資料共有していただけますか？
ああ、そうですね。
じゃあ、それでお願いします。はい。
Sharon, I have a problem. I cannot share my slides. Sharon, can you, do you have my slides? Can
Yes.
you?
I have them, and I can share them, and I can advance your slides.
Yes, please.
Okay. Can you see your slides?
Yes.
Okay.
Yes. Thank you. Oh, I'm sorry. I had a problem. So today, my name is Tamotsu Okato. I'm very happy to get an opportunity to give a presentation today in AIPLA and JPAA joint meeting. Today, I want to explain the DOA in Japan, and comparison with the DOA in the United States. Yes, next slide, please. これできるのかな？できない。Yes, today I want to explain the infringement DOE in Japan. Especially, I want to explain 1-5 requirements for infringement. Five requirements for infringement under DOE. Also, I want to explain the Supreme Court case and IP High Court case. The infringement under DOE in the United States. I want to skip this slide because you know much more than I know. So next slide, please. So then I want to explain the comparison with the DOE in the United States. I want to compare from the first requirement to the fifth requirement. And finally, I want to have a discussion with debating the festival resumption. 4-2 I wanted to have some discussion about the Supreme Court case law, but I don't think we have enough time. This is assuming some changing some background condition. Then what would have happened if I changed such condition? But I don't think I have enough time. So if you have any comments on that, I would appreciate your comments or feedback like that. Yes, thank you. Next slide, please. So this is literal infringement. The idea is exactly or almost same idea as the United States. The below is related patent law in Japan. Yes, next slide, please. So infringement under DOE. The DOE was first introduced in 1998 as a Supreme Court decision in the Ball's Flying case. So since then, many judgment has followed, and the DOA has been established in Japan. This is just a Ball's Flying figure for your information. Yes, next slide, please. So here is a 5 requirement for infringement under DOE. The first requirement, a part of patent invention is non-essential parts. A different part of a patent invention from the accused product is not essential part of the patent invention. The key word is non-essential part. The second requirement, a part of a patent invention is replaceable with the same operational efforts. So in other words, even if we replace the patent even if we replace the patent invention with one from the accused product, the objective of the patent invention can be achieved and the same operational effects can be achieved. So replaceable with the same function and same operational effects is a keyword. So the third one is replacement of the patent, part of the patent invention is easily conceived. So it is easy to conceive of replacing different part of the patent invention with one from the accused product at the time of manufacturing the accused product. So the key word is easily replacement. Replacement is easily conceived at the time of manufacturing the accused product. Yes, next slide. The fourth requirement is accused product is not easily conceived from publicly known technology. The idea of this requirement is, for example, everybody can create or combine that publicly known technologies. So in such case, we don't insist any infringement. So the philosophy of fourth requirement is to avoid such a product just created by publicly known technologies. So fifth requirement is accused product was not intentionally excluded during the prosecution. So there are not particular circumstances in which the accused product was intentionally excluded from the scope of the claims in the prosecution of the patent. The key word is intentional exclusion during the prosecution. So all the 5 requirements must be met to insist the infringement. So yes, next slide, please. This shows one Supreme Court case. It's 2017. It's not the new, but the latest case of the Supreme Court. Patent invention is a method of manufacturing a maxical stove. It's a medicine, inhibitor of proliferation of epidermal keratinocytes. So anyway, claimed method uses the cis vitamin D as starting material to create the maxical stove. So accused method use the trans vitamin D as a starting material to create the maxical stove. So discussion whether the fifth requirement is satisfied or not. In other words, accused product trans vitamin D was intentionally excluded from the scope of claims during the prosecution. Next slide, please. So this shows a part of vitamin D, and cis formula. For example, chemical formula are exactly the same, but the structure is slightly different. So claimed method use cis vitamin D. So the carbon double bond comes up this way, and on the other hand, the carbon double bond comes up this way. This is the difference. So so after discussion, as it was not suspected that there were such special circumstances in which the trans vitamin D is intentionally excluded from the claim during the prosecution. So the fifth requirement was satisfied as well. Of course, 1 to 5 was satisfied, and fifth requirement was also satisfied. So the conclusion was DOE was applied. Yes, next slide, please. So this is a IP High Court case. This is a 2016 case. So the specification says predetermined specified calculation of the web host system is performed on either system server or client server. So patentee amended the claims to perform the calculation in the client server. Accused product performs the calculation on the system server. So after the discussion of the IP High Court, due to the amendment during the prosecution, as it is construed that the calculation on the system server was intentionally excluded. So the fifth requirement was not satisfied. Conclusion, so the DOE was denied. Yes, next one, please. Next slide, please. This is a US case. So I want to skip this because you know very well. Next slide, please. Yes, yes. Also, please skip this slide. Please skip this. This one. Next slide, please. So just this is a rebutting first presumption by showing the 3 conditions, 1, 2, 3. So number 1 is unforeseeable. Second is amendment is tangential relation to the equivalent equipment. So third one is some other reasons. So anyway, there is a 3 conditions to rebut the first presumption. Yes, next slide, please. So now I'm going to explain the comparison with the DOE in the US. The first requirement, a part of the patent invention is non-essential part. So on the other hand, in the United States, the element by element rule may be applied. Warner, Jenkinson, something like that. So it seemed to me that all elements may be considered, even if the element is an essential part. This is a different part from the United States. Yes, next slide, please. Second requirement is a part of the patent invention is replaceable with the same operational function. So it seemed to me that the second requirement is a similar concept to the FWR function way result test in the United States. Yes, next slide, please. The third requirement, replacement of the part of the patent invention is easily conceived. So it seemed to me that there is no requirement like this in the United States. So yes, next slide, please. The fourth requirement, the accused product is not easily conceived from the public known technologies. Also, it seemed to me that there is no requirement like this in the United States. Yes, next slide, please. The fifth requirement, accused product, was not intentionally excluded during the prosecution. So it seemed to me to be the flexible bar and plus unintentional exclusion. So I think that all territories may not be always surrendered under DOE in Japan. Yes, next slide, please. Let's continue about fifth requirement. So I'm going to explain the middle of the line. It is said that the DOE in US is a flexible bar. It says United States is a flexible bar, but to me, it seemed to be a complete bar plus rebutting the first presumption. The patentee is responsible for rebutting the first presumption. But it does not. Oh no. Please. So it does not. It does not seem to be easy to successfully rebut the first presumption so far. So it's in the United States. It says flexible bar, but actually, I don't think so. Anyway, in Japan, similar condition to the three conditions for rebutting the first presumptions are not available. Yes, next slide, please. So rebutting the first presumption, it is my understanding, it is very, very difficult to successfully rebut the first presumption by showing three conditions. However, recently, last year in 2019, CFCA gives three cases that the patentee could successfully rebut the first presumptions. So I want to have your comments or ideas. In the future, CAFC becomes more friendly to the patentee to allow patentee rebut the first presumption. So later on, please give me any comments on that. And the next question is, I always think that how to avoid the first effects. Usually, we are not allowed to amend during the prosecution. So how can we avoid the prosecution? One of the idea is, can we avoid the first effects if we amend the claims before the U.S. examination? Before the U.S. examination, to avoid the rejection which were found in the corresponding application. For example, a patent parent application filed with the JPO. So in other words, we filed the application with the JPO first, then within 1 year, then we can finally get a final conclusion and cited references. So after that, we can amend the preliminary amendment or amendment in PCT bypass application. So before the examination, can we avoid that? Can we avoid the first effects in that case? So I'd appreciate if you have any comments on that to that. So next slide, please. So this is I don't think I have enough time, but this is some Supreme Court case. Here is some background or some conditions. So next slide, please. Next slide, please. If I change some background condition, what would have happened in that case? This is number one. Next slide, please. Next slide, please. Yes, this is another condition. I changed some. Yes, these are I wanted to discuss, but I don't think I have time. Sorry, sorry for trouble. And that concludes my presentation. If you have any questions, please let me know.
Thank you, Okato-san.
Yeah.
Does anyone have a question? So I have a question. I've
Sure.
presented it in the group chat room, but I will read it to you as well. So in Japan, when considering the fifth requirement, can a disclaimer in the remarks, not an amendment, but can a statement in the remarks of an office action response be construed as an intentional exclusion?
Yes, without amendment, they are considered some evidence. For example, if the patentee write some evidence in the specification or some papers, that may cause intentionally exclusion without amendment. That may happen. That may happen. So this is a quick. This is sounds curious, but without amendment, the court will consider: is there any intentionally exclusion?
Okay.
Based on the other information.
Well, thank you very much for your discussion. We've received your questions, and I'm sure we can have some communications by email to discuss
Sure.
the points you raised in your slides. So thank you
Okay.
very much.
Thank you very much. So thank you.
You're welcome. So next, we will hear from George Lewis of AIPLA, and he will be discussing recent Supreme Court trademark decisions. George?
Can you hear me?
Yes, I can.
Okay, I'm waiting for my slides to go up. Sharon,
Very good.
we cool? That says Todd Baker.
It does. I think that Daphne's going to try to share your slides.
Okay, that's it, I think. I hope I sent her my most recent version. So I'm going to discuss some recent trademark decisions by the Supreme Court. This is unusual. The Supreme Court doesn't usually decide a lot of trademark cases, and this year it decided 3 cases. And I'm going to try and discuss them in some level of detail that the time permits. Next slide, Daph. So the 3 cases are the Lucky Brand Dungarees versus Martel, Romic Vastus Fossil, and the USPTO. I'm actually going to discuss them in reverse order, though. Daph, next slide. So Booking.com, I guess, is like the big case of the year that everyone has read about, heard about, and curious about. And is probably familiar with the website. Booking.com is an online booking site, mostly booking hotels, but also flights and vacation packages. But it's just kind of a typical site that we're all familiar with, where you put in your dates and you're able to make your reservations there. They sought registration of Booking.com for a variety of goods and services related to the booking of hotel accommodations. These included hotel reservations, hotel rooms, resort hotel room reservations. It's all related reservations. Next slide, please. Their first office action for their, and incidentally, this application was filed, so this was an extension under the Madrid Protocol. So there was no allegation of use in the application, and they weren't required to allege use in the application. So the application was initially rejected on the grounds of descriptiveness. Needless to say, the term booking was considered descriptive of reservation services, and there is a rule of the Patent and Trademark Office that top-level domain names like .com and other names or other terms like corporation or company or Inc. or LLD or T or LLC, these are all considered non-distinctive marks that have they're inherently non-distinctive. They do not serve a trademark function. So on considering the application, as far as examiner was concerned, the mark of the application was booking, and that was descriptive. Next slide, please. So, the applicant filed a response. They claimed, first of all, they certainly argued that it wasn't descriptive. But then, even if it was descriptive, they sought registration of the mark under Section 2F of the Trademark Act, which is the provision that allows for marks to be registered, otherwise descriptive marks, to be registered on the principal register upon a showing of acquired distinctiveness or secondary meaning. In this case, they took advantage of a provision that provides for a presumption of acquired distinctiveness if you can allege 5 years of substantially continuous and exclusive use from the date that the claim is made. And that is a very typical way of proceeding under of obtaining registration under Section 2F. Next slide, please. So a second office action issued, and it maintained the rejection under descriptiveness, and the examiner said, this mark is so descriptive that you would need a lot more evidence to support a claim under Section 2F. But the examiner came up with a second ground of refusal. This refusal was that the mark was generic, that the mark is the name of the services. It's not descriptive of the services, it is the name of the services. And again, the examiner, in order to reach this conclusion, discounted the significance and in fact, the existence of the top-level domain .com. Again, the analysis was as if the mark was merely, excuse me, booking. And under those conditions, it was deemed generic. Next slide, please. Now, this is really very important under US practice. I'd be curious to know if it's the same under Japanese practice, because there is a distinct consequence to being held generic versus being held descriptive. Descriptive terms can be registered under Section 2F. You can come in and make a showing of acquired distinctiveness or secondary meaning. You can present evidence of sales. You can present evidence of a period of use. A mark of, excuse me, that is deemed generic is simply not registrable. It doesn't matter how much use you have. It doesn't matter how many sales you have. The mark, a generic term, is deemed the name of the goods. And you simply can't obtain registration for the name of the goods. Next slide, please. So the applicant appealed. I mean, there were several other office actions back and forth. They went to the Trademark Trial and Appeal Board. Trademark Trial and Appeal Board upheld the decision of the examiner. The applicant appealed, but one of the things the applicant did, which you can do, which is noteworthy, is rather than appeal to the Circuit Court of Appeals, the applicant appealed to a district court. And the significance of appealing to the district court is that the applicant was able to introduce new evidence into the record. And so this time, they spent money, and probably a lot of it. And they went out and they got a survey, and that survey evidence showed that 75% of consumers recognize Booking.com as a specific trademark for the applicant's services. All right, so the case eventually reaches the Supreme Court. Next slide, please. And the issue really before the Supreme Court was whether or not the top level domain changed the nature of the mark so that Booking.com in entirety could be considered generic. And as I've said before, the position of the Patent and Trademark Office is and has been, probably still is, that .com is non-distinctive, inherent. There's no inherent distinctiveness, does not perform a trademark function, it can never be an indication of source, and that the term booking is what the mark is and what should be considered. Whereas Booking.com argued that marks should be considered in their entirety, and that the mark should be viewed as Booking.com, not Booking, and that they should be able to make a case that the public recognizes that mark. Next slide, please. So, and in fact, one of the curious things is that the Supreme Court in its decision referred to the nature of this mark as generic.com. So what they were considering was the registrability of a generic name. By the time we reached the Supreme Court, no one was arguing further that generic, that Booking wasn't generic. The argument was that Booking.com was, as a whole, was registrable. And in fact, the Supreme Court took a look at the survey evidence, and that it was recognized as a brand and determined that it should be permitted. And this is an example of what I have discussed during many trips while in Japan, of what I call the George Lewis duck theory of trademarks. And the Supreme Court has from time to time basically ruled that if it looks like a duck, walks like a duck, sounds like a duck, it's a duck. And I've taken the position that if it looks like a trademark, is used as a trademark, and the public perceives it as a trademark, it's a trademark. And clearly, they accepted the evidence in this case that Booking.com was perceived to be a trademark. Next page. So usually after a decision like this, people are concerned that the world will come to an end. that suddenly everyone's going to start registering generic names, and there's going to be a rush to do this, and the system of trademarks will be totally subverted now going forth. But decision does not do a lot of things. It is not now the case where you can merely attach .com to any generic term and obtain registration. You'd have to make an incredible showing in order to obtain registration for the mark in that way. It's simply, this particular case, it was Booking.com made that showing, but we're not going to start removing generic terms from the vocabulary because of this. Okay. The other thing is that while they may have obtained registration for Booking.com, this is in no way evidence of exclusivity or creates no presumptions of exclusivity to the term booking for Booking.com. In fact, Booking.com in a record at some point in these proceedings indicated that it wouldn't raise objections to eBooking.com. So it's not preempting third-party right to use descriptive or generic names. It is long held that marks, that not all marks are equal, that some marks are stronger than other marks. Weak marks are those marks which we talk about highly suggestive, or in this case, this mark would be a generic term with .com after it. No one is going to be able to claim that that's a strong mark. They would have to tolerate other marks using booking, because cases would hold that even slight variations, because of the weakness of the mark, would result in marks being distinguishable. So, I mean, they allowed them to take the combined mark rather than dissect it. They allowed they allowed Booking.com to make the case that it was recognized by consumers, but the presumptions afforded by the registration are limited. Next case. Next page, please. So the next case is Romic Fasteners and Fossil Inc. These parties apparently didn't like each other. They engaged in a series of litigations starting sometime in 2001 over the term lucky. One party used get lucky, the other party was using lucky in some format. They sued, they settled. Apparently the settlements themselves weren't, let me back up. This case has involved damages. My error. This case involves Fossil and Romeg, and the bottom line decision of this case is that you do not have to prove willfulness in order to obtain damages. There is a split in the circuits whether or not willfulness was a requirement in order to, not damages, in order to obtain profits, rather the infringer's profits. I'm sorry, but this is past my bedtime. So Romig made fasteners. Fossil made jeans and other types of clothing. They had a factory in Japan that was making their jeans. Romig, I guess maybe other people aware of this, they're famous for their fasteners, and Fossil had an agreement with Romig to acquire their fasteners for their pants. The trademark was prominently displayed so that people, it was an attraction to the acquisition of the clothing to know that this fastener was involved. And what happened is that Fossil discovered at some point that their factory in Japan, who was supposed to be buying the Romig fasteners, was buying counter fasteners. And frankly, what was going on really probably is that both Fossil and Romic were being defrauded, because Fossil was clearly paying the Japanese factory to acquire the real thing. So Fossil was innocent party in that sense, and was probably again defrauded as well. Next. So, as you know, as I said, that whether or not profits were obtainable was a split decision. The board, the court went through a lot of analysis of all the different reasons why that couldn't be said. It's really not going into it. The bottom line was they concluded that you didn't have to prove willfulness. But it was important to note that the lower court held that the defendant, in this case, the gene maker, acted callously. They didn't say that they acted willfully, but they acted callously. Now, there was really no explanation of that. I presume that something that they should have known or spotted. I don't know. And the court did find that while willfulness wasn't required, that there had to be some indication of inappropriate behavior on the part of the defendant in order for there to be award of profits. Next page, please. Okay, the next case, I apologize, this is the Lucky brand dungarees. And this case involved the parties who were litigating forever about the terms lucky, get lucky versus lucky. They had multiple suits, and apparently they just didn't have a proper settlement. And so they repeatedly found themselves back in court. And in one of the cases, the 2005 case, Lucky had raised as a possible defense settlement, that whatever these issues were in this case, they were covered by the prior settlement. But for some reason, they didn't pursue that. So when the next case came along, the one that's the subject of this appeal to the Supreme Court, they again raised the argument that this matter was settled. Next slide. And so the issue here was whether or not there was something called defense preclusion, and whether or not it was a valid application of res judicata. Now, as my civil procedure professor taught us when I was in law school, generally speaking, you only get one kick at the cat. So you go in, you litigate, you're supposed to litigate everything, and when it's done, everything's done. And that's our doctrine of res judicata. One litigation to cover everything. And out of res judicata, there are two principles of law, which we call preclusion, and they are case preclusion or claim preclusion and issue preclusion. The plaintiff in this case, and I guess it was a theory that was prevalent in some of the circuits, wanted the court to recognize defense preclusion, which essentially was that, you know, this was a defense that should have been raised in the previous case, and it wasn't. And the court really said no, that it has to either qualify as claim preclusion or issue preclusion. There's no such thing per se as defense preclusion. Next slide, please.
Hey, George, about 1 minute.
Okay.
Please. Okay.
Right. So in any event, I mean, basically the court said that there was no claim preclusion here because the facts of this case were different from the facts of the previous case. Now, what was so relevant from a trademark perspective of this case is that the court really recognized that trademark facts are fluid, markets change, circumstances change, and that literally claim preclusion wasn't applicable because whatever the facts were that prevailed at the time of the prior litigation, the facts were now different. So So claim preclusion wouldn't apply because the facts were different, they weren't the same. Okay, I'll cut it short now. I'll look to see if I have questions.
Do you see the question from Kei Kanishi?
Yeah, I'm reading it. Kay
Okay.
wants to know, it's awfully small. The survey evidence seems decisive. What if the survey evidence showed slim majority of recognition instead? Probably not. They probably would not have prevailed. I think the evidence was overwhelming in their favor that the public recognizes a trademark. I don't know what a slim one is, 50-50, 51-49, but I think it would have been a more difficult case.
Thank you,
Okay.
Joel.
All right.
Thank you very much, George.
Well, okay. Is that it?
Any more questions for George?
Can't seem to get my video on.
There you go, George. We all see you.
You do?
We do.
Oh, I don't see you.
I see you.
Okay.
All right. Thank you, George.
Wait,
So our
another chat. Wait, is that another question? No. Okay. I'm gonna go get a drink now. By the way,
so our
just
last,
so
yes, go ahead, sir.
Todd and I started to grow our beards at the same time.
Yeah, about the different rates of growth, huh? So our final presentation for this evening will be from Tomohiro Takahashi, who will be discussing determining inventive step in Japan. Takahashi-san?
Yes, hello.
Hello.
Could you see my presentation?
Yes, it is visible.
Okay, so I start. Thank you for joining. My name is Tomohiro Takahashi from JPAA International Activity Center. Today, I'm very honored to have the opportunity to make a presentation. So, this is an overview of my presentation. First, I will explain the procedure of determining inventive step in Japan. Next, I will provide a historical review of determination of inventive step and introduce statistical data. Finally, I would like to explain about Supreme Court decision last year. Let's start. This is a basic procedure of determining the inventive step in Japan. The basic flow is exactly the same in the United States and Japan. First, the present invention and prior art are specified, and then they are compared to each other. If there is a difference, we proceed to determination of inventive step. This is legal provisions regarding inventive step. In Japan, the inventive step is stipulated in Article 29, Paragraph 2 of Patent Act. As in Section 103 in the United States, a person ordinarily skilled in the art is the criteria for determination. In addition, the phrase "be able to easily make the invention" is defined as a recitation corresponding to obvious in Section 103. As shown in this slide, in this table, it can be said that the concept of determination of inventive step in Japan is basically the same as that of the United States when compared with the Graham factors of the United States. This is the main factors for reasoning described in Japanese examination guidelines. The items on the left side show the negative factors that negate the existence of the inventive step, and the items on the right side show the positive factors that affirm the existence of inventive step. Motivation for applying secondary prior art to primary prior art has a history of changes accompanying the revision of examination guidelines. We will discuss this issue later. Advantageous effect is more often considered in determining the inventive step of chemical invention rather than an electrical or mechanical invention. obstructive factors correspond to arguments of teacher way in the United States. But I think obstructive factors in Japan tend to be admitted more often than teacher way arguments in the United States. Next, I will briefly review the history of determining inventive step in Japan. The JPO's General Examination Guidelines on Inventive Step was published in 1993 and revised in 2000 and 2015. Prior to the 2000 revision, the code was said to be stricter than the JPO. After the revision of the examination guidelines in 2000, the JPO and the code were very strict regarding inventive step. Around 2006 or 2007, the trend in the code began to change into more lenient one, and in 2009, this tendency became remarkable. After that, the examination standard on inventive step examination guideline on inventive step was revised in 2015. This table shows a revised portion in 2000. The 4 elements of motivation for combination of the prior arts are unchanged. However, the weight of the element of close relation of technical fields has changed significantly. The original version in 1993 states that a similar means capable of solving a similar problem in a related technical field can be strong grounds for the reason. Under this criterion, it was necessary to consider problem to be solved by the invention when considering close relation of technical fields. In contrast, the revised version of 2000 states that a replaceable or other means in a related technical field can be strong grounds for the reasoning. Under this criterion, it is possible to combine prior art by considering close relation of technical fields independently without considering problem to be solved by the invention. This table shows a revision in 2015. The 4 elements of motivation for combination of the prior arts are unchanged. However, the weight of relation of technical fields has changed again. The 2015 version states that with respect to the relation of technical fields, the examiner should also consider another point. Under this criterion, the factor of relation of technical fields should not be considered independently without considering other factors. In other words, the revision in 2015 brings the factor of relation of technical fields back to standard closer to the original version in 1993. Here is an example of a combination. This is invention relates to polishing roll. In this case, the JPO rejected the application due to lack of inventive step, and the court affirmed the JPO's decision in 2004. The features of the present invention are shown in the 3 differences separately. In this case, the applicant has submitted various arguments. For example, the respective prior arts have different problems to be solved. The basic configuration of the respective prior arts are different from each other. The applicant argues that there is no motivation for combining the prior arts. However, the court ruled that if the primary prior art and the secondary prior art pertain to the same technical fields, the motivation for combining the invention should generally be acknowledged unless there is an obstructive factor against the combination of the inventions. All the arguments presented by the applicant were dismissed. This judgment directly expressed the strict standards around 2004. This invention is so simple, so the conclusion might be the same even under the current standards, but the logic should be different. Under the current practice in Japan, the applicant arguments that the respective prior art have different problems to be solved, or that the basic configuration of the respective prior arts are different from each other, should be more carefully considered, even though the existence of the inventive step of the present invention is finally denied. This is a famous judgment that directly shows the change in trend in the code in 2009. In this case, the court reversed the JPO's decision of refusal. This is a ruling in 2009. The court stated that it is necessary that there is an implication or the like suggesting that he must have made such an attempt with the intention of reaching the characteristics of the invention. After that, it is said that tendency of the JPO in determining inventive step has changed. Let's take a look at the history I just explained with the statistical data. This graph shows the transition of success rate at IP High Court in lawsuit against appeal decision of rejection by JPO. Of course, not all cases relate to inventive step. However, certain trends can be read on the statistical data. From 2004 or 2005, at 2004 and 2005, the court affirmed the JPO decision of rejection with a high percentage. In 2009, court rescinding JPO decision of rejection with a significantly higher percentage than before. This graph shows changes in success rate of appeal at JPO. Since 2009, the success rate of appeal has begun to rise. It seems that the JPO appeal judges follow the change of the code. This graph shows rate of decision to grant of initial examination stage at JPO. Since 2010, the rate of decision to grant has begun to rise. It is currently stable at a high level. It can be said that the JPO appeal judges follow the change of the code, and after that, JPO examiner follow the change of appeal judges. Next, I'd like to introduce a Supreme Court decision last year. It is in this pharmaceutical case, the unpredictable and remarkable effect in determining inventive step was discussed. The present invention relates to human conjunctival mast cell stabilizing agent containing a specific compound. Today I call it compound A. Compound A being prepared as a topically administrable eye drop for treating human allergic eye diseases. This issue is whether the issue is whether unpredictable and remarkable effect of the present invention is acknowledged. More specifically, what is the comparison basis when considering an unpredictable and remarkable effect?
Excuse me, Takahashi-san, we have about 2 more minutes.
2 more minutes, okay.
Yes, thank you.
This diagram shows outline of this case. The present invention has a feature of compound A used as a human conjunctival mast cell stabilizer prepared as a topically administered eye drop for treating human allergic eye disease. Reference 1 discloses compound A. Reference 2 discloses inhibiting histamine release from mast cell. However, reference 1 and reference 2 do not disclose the effect that compound A exhibits an inhibitory histamine release from human conjunctival mast cell. This case went back and forth between JPO and the IP High Court 3 times. In the third trial decision, the JPO has found the present invention to exhibit unpredictable and remarkable effect and has decided that the present invention involves the inventive step. However, IP High Court denied the inventive step of the present invention based on the fact that it was already known that other compounds different from compound A exhibit similar effects to the present invention. In other words, the IP High Court concluded that the effect of the present invention not unpredictable and remarkable by comparing the effect by other compounds different from compound A. But Supreme Court ruling denied the idea of the IP High Court. The Supreme Court states that all of the other compounds have different structures from that of the present compound, and none of the other compounds is related to difference 1 and 2. Further, differences 1 and 2 do not disclose whether the present compound exhibit a histamine release inhibiting action from the human conjunctival mast cell, only rely on the fact that each of the other compounds which exhibits a similar effect to that of the present compound but has a different structure was known. It cannot be denied that the extent of the effect of the present compound is remarkable. The Supreme Court remanded the case to the IP High Court in order to make the issue on unpredictable and remarkable effect further considered. In the remanded case, the IP High Court acknowledged the unpredictable and remarkable effect on the present invention. This is June 17th this year. Thank you for your kind attention. That's my presentation. Okay. Okay. I received one question. In order to establish inventive step due to the existence of unpredictable and remarkable effect, does the effect have to be disclosed in the patent specification, or can evidence of the remarkable effect to present it in declaration or affidavit? Generally speaking, we can submit report of the unpredictable or remarkable effect after the filing of the in order to establish the inventive step, but it is preferable in to be described in the original disclosure.
Oh, thank you very much, Takahashi-san, for answering that question. I apologize. I was going to read it to you, but realized my microphone was on mute. So thank you very much for that answer. Are there any other questions?
No.
Thank you very much again to all of our presenters. It was a very informative evening and morning in Japan for us to join. Before we go to closing remarks, I would like to thank Noriko Sakashita, Chris Fields, George Lewis, and Sharon Israel for arranging and hosting this meeting. It has been a relatively large effort to present these virtual discussions, but I think it's been a very good use of our time. Now I would like to turn over the virtual meeting to AIPLA's first Vice President, Patrick Coyne. Patrick?
Thank you, Todd. I very much appreciate the time everybody put into these presentations. This was a great meeting. I know it is very difficult when we're in this situation where we can't get together in person, and it is very stressful. And I know, like many of you, I'm suffering from Zoom fatigue as well. But I really appreciate the clarity of these presentations tonight. They were very helpful and very clear and very direct. And in particular, I really enjoyed learning more about equivalence in Japan. It's a topic that me as a trial lawyer I'm always very interested in. And it's a very detailed analysis in Japan, what I've learned over the years. And I thought the explanation was excellent and very concise. And the same with respect to inventive step. It's an issue that troubles us as US practitioners a great deal. And it was very interesting, Takahashi-san, to learn more specifically about the steps in the analysis that are employed in Japan. So we thank all 4 of our presenters very much and appreciate your willingness to engage with us in these continuing discussions in this format, in spite of the COVID restrictions that make it somewhat more difficult than we would prefer. So again, thank you very much. And Todd, thank you for hosting. We appreciate it.
Thank you, Patrick. Next, we would like to hear from JPAA's Director General, Mr. Shinichi Watanabe.
Thank you, Todd-san. Hi, everyone. I'm Shinichi Watanabe. First, I'd like to thank all of the speakers for the enlightening presentations. As always, I learned a lot. Thank you. And thanks to new technology, it's great to be able to see each other and share information in this way while staying far away from each other. Using these new tools, I hope we can further strengthen the bond between AIPLA and JPAA. I look forward to the next web meeting in near future, and I'm really looking forward to the subsequent networking session and having a conversation with you. Let's have a good time together today and sing together in next April in Tokyo. Thank you.
Thank you very much, Mr. Watanabe. That ends our substantive part of the virtual meeting. For those who have been invited to participate in the networking, please stay online. We are going to be